Lot of talk about Luigi Mangione, the suspected killer of UnitedHealthcare CEO Brian Thompson, but with mounting evidence, what is going to be his legal defense? And with so much outpouring of support, does he even need one? Let's talk about it. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Hey, so before we jump into the story, I have a major announcement for you. The video version of Sidebar is now available on Spotify. That's right. We are so thankful for your guys' support of Sidebar and us getting the show on Spotify video. It is truly due to how loyal this audience is. So thank you so much. And yes, you can now watch and listen on the go, from the UnitedHealthcare murder updates to Diddy, Jay-Z, crazy court moments. It's all on Spotify now. So right now, you can scan the QR code on screen, click the link in the description to follow Sidebar on Spotify. Here's a question for you. What will be Luigi Mangione's legal defense? It's interesting, right? It's interesting because there seems to be a significant amount of evidence against the 26-year-old suspected shooter of UnitedHealthcare CEO Brian Thompson, who was gunned down on the morning of December 4th outside of the Hilton Hotel in Midtown Manhattan. And it was last week when NYPD Commissioner Jessica Tisch announced at a press conference in Staten Island that fingerprints found on a water bottle and this protein candy bar near the crime scene matched those taken from Mangione when he was booked into jail in Pennsylvania. Also, the gun found in Mangione's possession during his arrest has been matched to shell casings recovered from the shooting scene. The surveillance images taken from New York, I'm talking about the unmasked photo of the suspect at a hospital that he may have been staying at, the Starbucks before the shooting, at the crime scene, in a taxi after the shooting. They are what may have led to an identification in the McDonald's in Altoona, Pennsylvania, where Mangione was ultimately arrested. And it's even been reported by ABC that Mangione's own mother, Kathleen Mangione, spoke with the FBI the day before he was arrested, and that she even indicated that he could be the CEO killing suspect based on those surveillance photos, although she wasn't 100% sure. But I'm talking about the evidence here. And then he was found with fake IDs, including allegedly giving police in Altoona a fake New Jersey driver's license that authorities believe is the same one that was used to check into the hostel days before the shooting. This is according to CBS. And then, of course, how could I not talk about the manifesto and the notebook, these writings that were found when he was arrested. Writings that allegedly say, "To the feds, I'll keep this short because I do respect what you do for our country. To save you a lengthy investigation, I state plainly that I wasn't working with anyone. I do apologize for any strife of traumas, but it had to be done. Frankly, these parasites simply had it coming." Regarding UnitedHealthcare, saying that it's grown and grown, but has our life expectancy. No, the reality is these have simply gotten too powerful and they continue to abuse our country for immense profit. And according to CNN and ABC, there was also this passage about apparently deciding not to use a bomb because that would kill too many innocent people and that a shooting would be more targeted. And also, what about this alleged statement? What do? You whack the CEO at the annual parasitic bean counter convention. But there has been this overwhelming support for Mangione amongst a certain segment of the population. And you talk about defense. I mean, an online effort to raise money for his legal defense on a crowdfunding site has reached over $130,000. Yeah. Social media users on TikTok and Instagram, they are praising him, hailing him as a hero, and also, I guess for a lack of a better phrase, fanning over pictures of him. You know, Bop to the Top Tour's Jingle Bop that was held at the Big Night Live venue in Boston, it was just a few days ago. The DJ puts up on the screen pictures of Mangione, and the crowd starts cheering and going nuts. One of the clips was shared on TikTok, has over 1.2 million likes. Online support for the CEO murders apparently raising concerns of increased violence, copycat attacks. This is according to a newly released report from the Center for Internet Security. That report, obtained by CNN, warned that online discourse surrounding Brian Thompson's killing is emboldening individuals with violent intentions, especially against the healthcare industry and corporate America. So it makes me wonder, after hearing everything, will a jury even convict him? What could be his legal defense? Assuming you get a fair and impartial jury, though, what would be his legal defense? And that's what gets really interesting. Is there a challenge to the evidence? Is it a mental health defense? Is it an appeal to the juror's sympathy? By the way, as I hope you know, here on Sidebar, we don't try to put a spin on anything. We try to deliver balls and strikes with these stories, like with Mangione, just the facts. And that is why we are thrilled to partner with a company like Straight Arrow News, which is an app and website that is focused on objective, unbiased reporting. As somebody who is always doing research for Sidebar, I know how easy it is to get lost in biased journalism. But Straight Arrow News helps us cut through that with tools like the Media Landscape, which shows where outlets fall on the political spectrum, the Media Mist tool, highlighting stories that mainstream media might be skipping. So check it out for yourself for free by going to san.com/sidebar or click the link in the description. Supporting them means supporting journalists like us committed to delivering the truth. I want to bring on right now criminal law attorney Safa Robinson-Ferrer to talk more about this. Safa, thanks so much for coming on. I want to focus primarily on the New York charges, not necessarily the Pennsylvania charges, because although those are serious, forgery, firearms offenses, it's really the most serious charges are in New York: second-degree murder, weapon possession, and forgery charges. So besides we get into the legal defenses, do you think there's a real possibility of jury nullification at either the grand jury or trial level, meaning the jury doesn't decide this on the facts or the evidence, but emotion, sympathy, their anger against the healthcare industry? What do you think?
Well, that's certainly a possibility, but that's always something that we look to avoid as attorneys, and especially as the prosecution and the defense begin to present their cases. One of the things that they're going to do during the voir dire process when they interview these jurors or potential jurors is they're going to ask them, will you keep sympathy out of your deliberations? That is a question that is always asked during jury selection, and it's generally asked by both sides. Each side, the prosecution and defense, want to ensure that the jury is not going to lean on sympathy to either bring about a conviction or to acquit the individual that's charged.
But there's not a thorough jury selection process in grand juries, right? Grand juries, it's basically like, do you want to serve in this grand jury now, or do you want to come back in 6 months? So I remember I served on a grand jury. There was no voir dire. They didn't ask if I knew any of the defendants in the cases that I was covering. It was just, is there enough to indict? And, you know, I wonder if you have random New Yorkers who maybe some of them feel some sympathy towards what the alleged shooter did here. At a trial, the defense can't say he did the right thing. The health insurance industry is killing people. He took a stand. It was a symbolic stand, killing Brian Thompson. That's not a legal defense, right? That won't be, the judge wouldn't allow that, right?
No. But what could happen, though, is that when you have jury selection, you have jurors that come in and they have all types of different experiences. You have jurors there, who may have had negative experiences with insurance companies. And so they bring that experience to the jury room, to jury selection. And sometimes jurors aren't as honest and transparent as we would like them to be. So there could be a situation where we have maybe one or a few rogue jurors who believe in this cause that this individual allegedly, or the reasoning behind why he allegedly did what he did.
Yeah, there could be stealth jurors, right? They say all the right things to go on to that jury, but they really have different intentions. I mean, I imagine it also will be an effort, even probably by prosecutors, to do background research on these jurors, right? To look at their social media accounts. You can do that, right?
Absolutely. While we're picking our jurors, we oftentimes will have someone who's assisting us, whether it's our paralegals or our juror selection specialist, and we're plugging in each and every name of every potential juror. We're scoping their social media. We have the juror questionnaire, so we're judging essentially who we're going to want to sit on our jury, what their profession is, if they're married, if they have any religious views. One of the interesting things that we find oftentimes is that a lot of people who have certain religious views don't like to pass judgment on other people. So as a defense attorney, that's great for us, because we don't want a situation where the juror is going to pass judgment on our client and that judgment be of guilty. So there's a lot of things that go into jury selection process. We are looking at social media. We are looking at the juror questionnaires to figure out who's the best fit for our side.
So putting aside, let's say you get a fair and impartial jury for both sides here. Okay, now we have to talk actual, legitimate legal defenses. I'm going to go through a few of them. I want your perspective. The first is, how do you get rid of this evidence? So the fingerprint evidence, the ballistics, the surveillance, is there a way to strike at that evidence? Is there a way for it to not come in, or strike at the reliability of that evidence? Talk about what some arguments we could expect to see from the defense. Maybe not only at trial, but going into trial, motions leading up to trial.
Absolutely. And the defense team is going to have to attack quickly and early before we even see a trial these pieces of evidence. What's going to happen, or what I expect that the defense is going to do, is during the motion period where we request certain legal relief, they're going to have to challenge how this evidence was obtained. If there was a search warrant, they're going to have to challenge the validity of that search warrant and if there was probable cause to obtain that search warrant. If there is no search warrant, and I believe there probably is, considering the facts as we know them to be at this moment, but what occurred or what was located incident to a lawful arrest, challenging those things. When Mr. Mangione was taken into custody, what was located on him that would have been an exception to the search warrant requirement that we have here. Not only that, but as we continue to go forward, we're also going to be challenging the reliability of these pieces of evidence. There is a way that evidence needs to be moved in at trial. It has to be properly authenticated. So whatever video footage was obtained from in this incident, where it was obtained from, how it's stored. Is it stored in the ordinary course of business for whatever company may have had that footage that the government obtained from them? All of those things have to be challenged, and all of those things have to be perfected at trial. At trial, there has to be a foundation that is set so that these pieces of evidence can come in, so this video footage can come in, so anything that was obtained incident to a lawful arrest can come in. There has to be a proper foundation that is laid so that those things can even come in, and I expect that the defense is going to attack the ability for the prosecution to bring those things in early on.
Yeah, it's interesting. There were search warrants in this case for, the backpack, the phone that was collected. I think there was also one for the hostel. But, look, it seems to me the difficulty for the defense was the timeline of everything, right? So first they collected the backpack and the phone, the things that were at the scene, which it seems like law enforcement would have a right to do. And the fingerprints were only matched up to the items at the scene once he was in custody. So they took his fingerprints and matched it. And then the ballistics were matched to the weapon that he had on him. Do you think that might be difficult to say, it wasn't handled correctly? Maybe their best avenue is to say, when it comes to the fingerprints of the ballistics, this is not a true science. The science is a little wonky, or the way it was handled, it was mishandled and maybe contaminated. What do you think?
Absolutely, most definitely. And one of the arguments that the prosecution is actually going to make with respect to this backpack is that it was abandoned property, that once he left it on the sidewalk or got rid of it, that it's abandoned, that he no longer has standing to challenge the evidence at that point, or what was ultimately obtained at that point. With respect to the evidence in terms of fingerprint testing and ballistics, the defense is going to have to hang on to that scientific, challenging the science behind it. What people don't often realize, although in this case we do believe that there have been fingerprints that were located, is that not often do we find that there are fingerprints or DNA on firearms. In fact, the grips of the firearms or certain types of firearms that are made are actually to prevent fingerprints from being placed onto that firearm. Doesn't appear to be the case here, but all of those things are taken into consideration as the cases proceed and how you build your prosecution or your defense and things like that.
That's a really, really good point. And real quick about the surveillance footage, would they say, hey, how can you definitively say this is Mangione in the surveillance footage? It's grainy unless they use some sort of technology to enhance the photo. A lot of times the person's covered. So maybe they would say, that's not the same person in the hostel as the same person in the taxi. Is that ways to try to say that it's not who the government believes it is?
Yeah, absolutely. One of the things the defense is also going to want to do here is challenge the identification. In order for the prosecution to meet its burden of proof beyond a reasonable doubt, one of the things they have to prove is that this particular person on this time, date, and place committed this specific act. And they have to prove beyond a reasonable doubt that it was this person, in this case, Mr. Mangione. And so the defense should be picking away at each and every moment that led up to this incident with Mr. Mangione, and also raising and creating doubt with respect to that. Now, it may be difficult considering the layout of events and in totality, or taken in totality of the circumstances, the evidence could appear that it is essentially him, but they're still going to have to pick away at it. They have to do everything that they can to protect their client, protect their client's interests, and challenge the evidence every step of the way.
How do you fight against the writings that I mentioned? Do you say it wasn't him who wrote it? Or yes, he wrote it, but he didn't actually confess to the killing. It can be interpreted multiple ways. Is that how you fight against that? Or is there a way to make sure those writings aren't even admitted into trial?
That's where we're going, is we're going to ensure, or hopefully ensure, that those writings don't come into trial. First, back to that motion period and challenging the search warrant, or however that writing was obtained, we're going to first challenge that there. After the motion period, more than likely, and in this case, there will be what we call suppression hearings. And those are hearings, sort of like a mini trial, that take place where the law enforcement officers are going to get on the stand and testify as to how they obtained that search warrant, how they executed that search, and things of that nature. And so the important thing there is going to be to exploit and show any illegality of police conduct. Holding on to the alleged fact or possible fact that the police did something illegal, and as a result of that illegal activity, this piece of evidence should be suppressed. And so that's where the defense is going to want to go with that. If those writings stay in, then there's an ability to challenge it at trial as well. Again, with the proper foundation being laid for that to come in, and challenging that on the defense aspect, also saying, well, you don't really know who wrote these. You weren't there. You didn't see him write it. You've never met him before. You've never seen him write anything before. So you really don't know that is him. So it's not the strongest defense with respect to that, but that's certainly something that they could explore, among other things.
All right. So now, assuming that all comes in, assuming there's no denial that he's the shooter, what are the other defenses? Well, now let's talk mental health. So there has been a lot of talk about insanity. And essentially it would be, yes, Luigi Mangione shot Brian Thompson, but he's not criminally responsible. And I've seen talk about this. I don't necessarily believe it, but let's go through it. So my understanding under New York law is a person lacks criminal responsibility if they have a mental disease or defect, when at the time of this crime, as a result of that mental disease or defect, that person lacks substantial capacity to know or appreciate either the nature and consequences of what they were doing, or that such conduct or what they were doing was wrong. Now, again, this idea, he did it, but he really couldn't appreciate the wrongfulness of his actions. He didn't appreciate what he was doing. Do you think that applies here? Because I could make arguments that he sure did know what he was doing, assuming it was Luigi Mangione, wearing a mask, avoiding detection, holding a Faraday bag that conceals or blocks cell phone communications, trying to get out of there. It would all seem to suggest he knew that he was committing a crime and didn't want to get caught. Ghost gun that couldn't really be tracked. Again, that's why I feel like insanity wouldn't apply, but maybe I'm wrong.
No, I don't think it's going to apply here. They can certainly attempt to raise it, but the reality is, taking a look at all of the evidence and the totality of the circumstances, I don't think that that's going to be the case here. And again, they can certainly raise it if they feel that that they'd like to do that, and present a psychiatric defense, get their psychiatrist expert or whoever they're going to call in to testify about his mental state at that time. Also, while this matter is pending, there is the possibility to do what we call a 730 order, and that essentially checks to see the mental capacity and competency of an individual and their ability to aid in their defense. But considering that these acts appear to be premeditated, appear to be well thought out and planned, I don't think that a psychiatric defense is going to be the saving grace here on the defense end.
By the way, just going back to that evaluation, is that something that is petitioned by the defense? And does the prosecution have an attempt to put in their own experts to evaluate Mangione? How does it work?
With a 730 order, oftentimes we as defense attorneys will make that request when we question the psychiatric nature or the mental health nature of our clients at that time. Sometimes we have these conversations with prosecutors, and the prosecutor will agree, like, yeah, it seems that there's something going on here. Go ahead and order it. Sometimes they will oppose it, but it will ultimately be up to the judge to allow for that to go through. And more often than not, they do, in the abundance of caution. And you don't want any issues on appeal either. So what happens is, if the person's in custody, there's a psychiatrist through the institution that they're housed in that will perform that evaluation. The prosecutors are aware of it as well. I've never had a prosecutor actually submit their own evaluator, and they're not even often paid for by us if the individual is in custody. It's done through the state, and they will make the determination on whether or not that person is competent in trial.
See, look, I just think it's interesting when we talk about mental health because he had these outbursts leading up to his extradition hearing. He tried to speak in court. His writings or his alleged writings could be a bit erratic. But while I don't think insanity would necessarily work, I did want to ask you about extreme emotional disturbance. So there is a way to downgrade murder to manslaughter, which I understand could be 5 to 25 years in prison, very different than second-degree murder, which could be up to life in prison. So this extreme emotional disturbance, that a defendant had an emotional disturbance that was so extreme that he couldn't control himself, that the reason for it, it has to be reasonable. And you test reasonableness by putting a person in the defendant's shoes under those circumstances as the defendant believed them to be. And he had to have killed under the influence of this extreme emotional disturbance. I think a classic example would be, right, a husband comes home, finds his wife cheating, goes downstairs, gets a gun, comes back upstairs and kills them. Yes, you could say intentional murder, but also maybe acting under an extreme emotional disturbance. Do you think that may apply here at all?
I don't think that's going to apply here. This seems to be such a well thought out act, or for lack of a better way to put it, well thought out act, where he planned this, or he allegedly planned this. He had the proper equipment. He had identifications that to attempt to conceal his identity. He fled after this took place, there's an argument for consciousness of guilt with respect to that act. And so I don't think that the extreme emotional disturbance or crime of passion is going to really apply here. This isn't a situation where, he caught his partner cheating. This isn't a situation where he's murdering somebody to protect a child or his child. This is just something where stranger to stranger, this act takes place, in the public, and it appears again to be a thought out, methodical plan to do this.
Does he take the stand? Does he testify at trial?
Absolutely not. He has a right to remain silent, and he should certainly use it if he were to take the stand at trial. And certainly when you have homicides in particular, the jury wants to know both sides. They're very curious about what happened. And so they would like for, our clients or the defendant to testify. But in reality, if Mr. Mangione were to testify, I think he's going to get crucified on the stand by prosecutors. They already have enough evidence to seek a conviction potentially. He doesn't need to give them any more ammunition to do that. And if he were to testify or get on the stand and testify, what could he say at this point other than it wasn't me? And they're going to say, well, you did this on this date, you had these IDs, these were what were located with you. So it's going to be really difficult for him to get around that. I don't think that he's going to testify. I don't think that he should testify.
It's his choice, though. It's his choice. Even if his attorneys don't want him to do it, he might do it. But I wanted to ask you before we wrap up one more quick question about defense. So New York attorney Colleen Kerwick told Newsweek that she believes that Thomas Dickey, who's his lawyer representing him in Pennsylvania, and we know that Karen Friedman Agnifilo is representing him in New York, but Thomas Dickey might be using extradition hearings, because at the time of this broadcast, there is still a debate about extradition, about how he's going to be extradited back to New York if he's fighting extradition, that he might be using extradition hearings to test out legal defenses. Do you think that makes sense? Is that true?
That would essentially buy him some more time to think about his legal defenses. I don't think that that's going to be as significant as the time he's going to spend in custody pending trial, once he does get back to New York. And so what I do expect and anticipate is that at some point he will be extradited back to New York, whether he decides to waive extradition or go forward with the hearing. It's going to depend, but more than likely he will be brought back here. I highly, highly, highly doubt that a judge is going to set bail on this case. I think he's going to be held no bail, no release until his trial date, whenever that may be. And he's going to have all that time to sit and think about what his defenses are.
All right, and we will cover it right here on Sidebar and on Law&Crime. Safa Robinson-Ferrer, thanks so much for coming on. It was great seeing you.
Thanks, Jesse. Thanks for having me.
All right, everybody, that's all we have for you right now here on Sidebar. Thank you so much for joining us. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.